And answering the question today, how common is it for a individual inventor filing on their own to be successful in getting a patent granted? I'm JD Houvener, owner and founder and patent attorney at Bold Patents Law Firm, and I've helped thousands of inventors over the years, 10 years helping inventors do this. I've also written a book called Bold Ideas, The Inventor's Guide to Patents. And please get access to that on the Bold Inventors Kit below. Take action today, subscribe, and download. Let's dig into this question here, and the answer is yes. Pro se is the term, it's a Latin term, for inventors filing without the help of a patent attorney or an agent. File all the time. This is quite common. And I think it's on the order of 2,000 to 3,000 patent applications are granted to pro se inventors every year from the USPTO. There are some downsides. The biggest downside that I've seen in my over 10 years now doing this is individual inventors will get excited, want to save money, right? They're entrepreneurs, they're bootstrapping, they'll do some research and say, you know what, I can file this on my own. And the truth is, yes, you can. It's just a separate area of law and a lot of hoops to jump through. And it's a really steep learning curve in terms of what you have to know about filing the documents, preparing the spec, the drawings, to make sure that it fits within the realm of the patent examination procedure. The other major downside is typically the scope of rights, meaning the written words that are allowed or granted are usually quite narrow. This is because of two main things. One, the inventor, the pro se inventor, is typically thinking about their invention in terms of what they have built, the one solution that they have prototyped and envisioned for their success in the market. They're probably not thinking about other applications, other embodiments or versions of their invention that could reach other industries, other applications. And so they're thinking about, oh, I'm going to get a patent on this thing that I made, this widget, this software, this product that I have right here in my hand, because this is going to be a success in the market. Not truly thinking about the functionality or the structure, how materials could be different. And so the breadth of the scope gets reduced. Other major aspect of why the scope of rights is reduced is the examination and all the process in terms of what the examiner will find. Having not done a professional search, the inventor likely is going to be claiming too broad. And so the examiner is going to come back with rejections on novelty, saying, hey, some of this invention is not new. It's been done before. Half of your claims are not allowed. They might also say that these two prior references combined make some or the most of your invention obvious. And so having to overcome those hurdles on your own is quite challenging without legal experience. And so what you end up with is a very reduced or amended set of claims. Now you might think amended, reduced, limited scope, that the claims are small. But the trick is, what I usually see is a very long claim. And typically the longer, the more words that are in the claim, that's the smaller the rights. Because in order to infringe on that claim, you have to have every single one of those elements in the claim to be infringing. If you don't have just one of those elements, one of those limitations, all of a sudden you're not infringing that claim. And so the value is diminished. It's sort of a hallmark in a lot of these pro se inventor cases I see. They're excited they got their patent granted, and I take a look at the claim, and it's like 3 or 4 paragraphs, really detailed in terms of the elements, right? The elements that are in the claim are very detailed. It has to have, let's say, a certain number of attachments, specific dimensions even, so that they can't have something even bigger. It'll be limited to a shape or a certain structure or a specific type of material. And that really is too bad, because the value of the patent, it reduces almost to zero, because there's no way you'd be able to enforce that on an infringer. All they'd have to do is point out that they're not practicing one aspect of that claim. So, long story short, please don't file your invention on your own, because one, even though you can get a patent granted on your own, it won't be all that valuable. And number two, you'll waste your time. Even though you might be saving money, you'll spend a lot of time learning the area of law and honestly not focusing on what really matters, which is your invention, your business plan, and getting ready to go to market or preparing it for license or sale. Hi, everybody. Thank you for sharing or listening to this here with me. I'm JD Houvener, owner and founder here at Bold Patents Law Firm. If you haven't done already, please do click below on the Bold Inventors Kit. Grab your information, the free book, and the valuable resources I've prepared for you. Have a good rest of your day, everybody. Go big, go bold.